case briefs, and so much more. LSData's got what you're looking for.
In 1979, the Supreme Court of the United States heard the case of Friedman v. Rogers, which centered around a Texas law regulating how businesses advertise their goods and services. The dispute involved optometrists in Texas and the Texas Optometry Act, which established the Texas Optometry Board with the authority to regulate the profession. However, the Act's prohibition on practicing optometry under trade names was challenged as unconstitutional by a commercial optometrist, Rogers, who also argued that the Act's requirement for board membership to include 4 out of 6 members from the Texas Optometric Association deprived him of equal protection and due process. After a district court found the prohibition on trade names unconstitutional, the case was appealed to the Supreme Court, which sought to determine the constitutionality of the statute and whether the ban on trade names violated the First Amendment's protection of commercial speech. The Texas Optometric Association and the Texas Senior Citizens Association also joined the lawsuit. Ultimately, the Supreme Court held that the Act's restriction on trade names was constitutional and should be enforced, and that Rogers had a right to a fair hearing before the board. The requirement for board members to be from a professional organization was also deemed constitutional. The court affirmed the district court's judgment upholding the constitutionality of the Act, reversed the judgment regarding the prohibition of trade names, and remanded the case with instructions to dissolve the injunction against the enforcement of the trade name ban.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.